And in a larger point about how perhaps the courts are taking the adjournment way out of not making the hard decisions and keeping these matters pending. Mr. Singhvi is not the only big legal voice that we have on our show tonight. We've also got now Harish Salve, who's joining us on this show. A quick conversation with Mr. Salve as well. Good evening. Thank you so much, Mr. Salve, for speaking to us here on Mirror Now. Let me begin by where I left off the conversation with Abhishek Manu Singhvi, and that's on the latest controversy regarding the judiciary and the transfer of Justice Murlidhar and the way it's come about at this time. Is it fair to raise questions when the collegium had already recommended his transfer 2 weeks ago?
The problem is this: we, instead of discussing broad issues and discussing the structure of the system, try and pick individual instances. When the National Judicial Appointments Commission was contemplated for appointments and transfer of judges, a lot of people came and criticized them, saying you're taking away this power from the judges and you're putting it in a committee of people. And mind you, there also judges were in the majority. There was just one or two lay people and the law minister who was made a party. When we were also supporting the NJAC, we said it will bring much greater degree of transparency and much greater degree of accountability. That was criticized and said, oh, we must have faith in our judges. If you have faith in our judges and the judges take a decision to transfer one of their own, then to try and pick holes depending on one's own individual assessment of what a judge has done or not done is then putting the court in a very awkward situation. One of the reasons I've always said that the Supreme Court should not have either the power of appointment or the power of transfer is it puts the court in this kind of a situation that its individual decisions are put in question, depending, especially in present times, on in the surcharge atmosphere in which we are living. This creates a huge problem. Now, the judge has been transferred. Justice Murlidhar is one of the finest judges in the Delhi High Court. His integrity, his independence, his intellect, I don't think anything is in question. Why is he being sent to Punjab High Court? I don't know. Is the Punjab High Court a lesser High Court or a better High Court? These kind of comments are hardly called for. It's a very big High Court. It's the High Court of two states. He's being sent there. We don't know why he's being sent. Do you have faith in the Supreme Court exercising this power of transfer? If you do, then you must accept it has been done for the right reason. If you don't have faith in the Supreme Court exercising this power of transfer, then let's think of some other system. This kind of an individual sitting in judgment by people standing in corridors and gossiping, and this is for good reason, this is for bad reason, this undermines institutional integrity, and I don't think this should be done.
No, I completely agree with you, and perhaps it is time to once again relook at the entire appointment system, what we have right now versus the NJC that was struck down. But Mr. Salve, there is a point being raised about the way the transfer was implemented. In your experience, is this a routine to transfer out a judge like this immediately overnight when he's presiding over such an important case?
I don't know. As you know, Tanvi, I'm not in India. I've not been in India for a while, and I've not kept track of the day-to-day movements beyond reading on your news blurbs and the NDTV news blurbs. My impression is that there was an order of transfer which had already been passed. The collegium's decision to transfer Justice Murlidhar, I heard about this a while ago.
Yes.
Maybe a month ago or maybe. And the case came up just a day or two earlier. Now, I don't know when this transfer was implemented. I have no idea how it was done. But this is the whole problem. Either we have faith in our system or we don't have faith in us.
Correct.
The other problem I have with this kind of a criticism is underlying this is a assumption that if the case goes from Justice Murlidhar to another judge, the other judge will not have the same commitment to the Constitution and the same courage to deal with the case the way Justice Murlidhar was dealing with it. What are we trying to say? See, this is what happens when these kind of cases come before the court, and then the litigants and unfortunately even lawyers start feeling, oh, the judge is making favorable comments at one stage or said something, and then something like this happens. You say, oh, the judge is being transferred for this reason. Is the government? First of all, the government has nothing to do. Look at the sinister implications. The sinister implications are that the government is unhappy with what Justice Murlidhar is doing. And the Supreme Court has quietly and in complete dereliction of all its constitutional duties agreed to play ball with the government and transfer the judge. And that upon his transfer, the case will go to other judges who don't have degree of judicial. I mean, what are we saying? Do we understand what we are saying? We are criticized. Who can criticize the government till the cows come home? Who can? They are elected governments. They can be criticized. Oh, what are you saying about the Supreme Court? And what are you saying about the High Court?
Well, I think in this specific case, there are questions being raised against the collegium and the Supreme Court and the government to say all of this will fall into place to become a larger conspiracy so that one case about filing of FIRs in hate speech cases doesn't go to Justice Murlidhar anymore. But I completely get your point.
And it goes to another judge, and of course, that judge has not sworn an oath to protect and preserve the Constitution, and the case will go badly.
Yes.
So we have now criticized the whole Delhi High Court, we have criticized the Supreme Court, we have criticized the whole system that works, all on injunction. And I think this has to stop.
I agree. Mr. Salve, there is another larger issue that we are discussing tonight and putting the spotlight on, and that is the issue of adjournments and adjournments with a longer period of gap and time given in between. Now, Mr. Singhvi, not specifically talking about the case that we were referring to, but wrote a larger article, part of his upcoming book, where he says that courts seem to be deciding hard questions via adjournments. Would you agree that perhaps there have been far too many instances to support that?
Tanvi, let's be very clear. First of all, let's not confuse phraseology. Fixing a case and adjourning a case are two very different things. Adjourning a case is a case which has been fixed for a hearing for a particular date, but for the convenience of someone or the other, or the unavailability of a court is adjourned. The other is a court deciding when it wants to hear a case. Today, you have huge pendencies. And because of the pendencies, some certain cases are taken out of turn. Now, it is entirely for a court to decide the importance of a case. People standing in the corridor of the Supreme Court may feel very strongly about the importance of a case. People in public life may feel very strongly about the importance of a case. Judges of the Supreme Court may feel this is a politically significant but constitutionally not so important a matter. We will hear it after we hear some other case. What are the priorities of the cases from the perception of the judges is not necessarily the priority of the cases from the perception in public life or someone who is a lawyer. So, this to say that the important cases are being adjourned, only trying to say I would them to hear some other cases, some cases other than what they are hearing. I don't think to suggest, and the underlying suggestion is that the Supreme Court is running away from important cases. I think that's a very unfair comment.
But when a case about filing of an FIR in a hate speech comes up, a 3 weeks adjournment can make a life of a difference to that case.
Why was the adjournment granted? Who granted the adjournment? And sometimes there are cases where the court feels 2 weeks, 3 weeks time may resolve the issue. See, ultimately, the case issues such as filing an FIR are peculiar to Indian courts. In no other evolved legal system do such matters even come to a court. Constitutional courts, I have always maintained, constitutional courts are not designed to deal with day-to-day problems of whether an FIR is filed or not filed, or this happens or that happens. Yes, in India, the situation is different. At times, the Constitutional Court has to intervene and make sure that the rule of law is not hostage to politics, or rule of law is not hostage to an inept police. Having said that, just to say that just because one particular case of a particular kind was adjourned by 3 weeks, the court is shying away from its constitutional duties. I think that's an unfair. Our Supreme Court takes on difficult, in the sense, cases which have important consequences, cases which have far-reaching public significance, and decides them fairly and without any fear or favor. So if a particular judge feels that a particular case should wait for 3 weeks, to suggest that you may disagree with it. Say, no, I'm sorry, I think he should have heard it early. But to suggest that there is something more than that going on, I don't think is fair.
Fair enough. Harish Salve, always a pleasure to have you. And thank you for joining us, all the way from London on this very crucial debate. Appreciate your views.